Do you want to go ahead, turn the vehicle off, and step outside for me, please?
May I ask why?
Well, right now, you don't have a driver's license, all right? And I need to, once you step out here, that's why, all right? Seatbelt off.
But I would like to know why I have to step out just because I don't have a license.
Because I'm going to read you your rights, and I'm going to talk to you. I'm not going to ask you again.
Okay.
Step out of the vehicle.
That's all I wanted to know. All right, so you're arresting me?
Step out of the vehicle.
No, I want to know. You're arresting me?
I'm not going to ask you again.
I just need to know if you're... Excuse you? Excuse you? Excuse you? Absolutely not.
Co-10.
Excuse you? Oh my God!
I just said step out of the vehicle.
Marcus Hale thought the night would end with a coffee and a quiet drive home. Instead, red and blue lights lit up his rearview mirror. The officer leaned in, smiling, casual, friendly. Just a few questions, he said. Marcus answered one, then two. Then the tone changed. Suddenly the questions felt sharper. Accusations slipped in between pauses. The officer claimed he already knew everything. Marcus felt the trap closing, and he had no idea how fast a normal conversation could turn into evidence. That moment is where people lose their freedom, not because they're guilty, but because they talk. Police encounters are not conversations. They are strategic exchanges designed to get you to say one wrong thing. In this video, I'll break down 6 lawyer-approved ways to protect yourself and shut down bad situations before they spiral. If you value your rights, hit like, subscribe, and stay sharp. 1. Police can lie to you. Your words are their weapon. An officer sits across from you and speaks with certainty. He says the evidence already lines up. He hints that someone else talked. He implies cooperation will bring relief. That confidence feels convincing, yet it carries no obligation to be true. Law enforcement interrogation allows deception as a tactic, and that power exists for one reason: to trigger speech. Deception works because people instinctively respond to authority with explanation. Silence feels uncomfortable. Correction feels necessary. The moment speech begins, the dynamic shifts. Investigators gain material. They shape timelines. They isolate phrases. They document selectively. Intent fades. Words remain. Every answer creates leverage. Even accurate statements can harm. Memory gaps sound like evasion. Adjustments sound like inconsistency. Tone disappears once written. Reports preserve content stripped of nuance. What feels like clarification becomes ammunition. This practice has survived legal scrutiny. The Supreme Court confirmed in Frazier v. Cupp that deceptive interrogation tactics fall within constitutional bounds, meaning officers carry no duty to disclose truth during questioning. Understanding this rule reframes encounters entirely. Friendly delivery does not signal fairness. Certainty does not equal proof. Pressure often masks absence of evidence rather than strength of it. Silence interrupts strategy. Speech completes it. Once words leave your mouth, control shifts permanently. Investigators gain freedom to interpret, reframe, and deploy statements in ways never intended. That reality explains why calm confidence from law enforcement should raise caution rather than comfort. Power stays with the person who controls information. Talking transfers that power instantly. 2. If they're asking questions, they're fishing for evidence. Police rarely ask questions when a case stands complete. Arrest follows certainty. Questions follow gaps. That pattern repeats across investigations. Calls continue. Meetings stretch. Topics circle back. Each exchange exists to close holes. Fishing depends on patience. Investigators revisit details from different angles. They test consistency. They listen for shifts. Over time, fragments combine into suspicion. Even truthful answers evolve into risk once compared against developing theories. Many people believe cooperation speeds resolution. In reality, cooperation supplies raw material. Investigators document selectively. Reports emphasize points that support direction. Innocent explanations lose context once written. What remains feels definitive despite uncertainty at origin. Another trap lies in repetition. Answering similar questions across days creates variation. Language changes naturally. Memory adjusts. Those changes attract attention. Inconsistency forms without intent. Pressure grows quietly. The legal system assigns investigation to law enforcement. Citizens carry no burden to assist. Speaking reverses that structure. Silence preserves it. Representation changes everything. Once counsel appears, fishing ends. Communication reroutes. Evidence either sustains progress or momentum disappears. That outcome exposes truth. Strong cases survive silence. Weak ones depend on speech. Investigators understand this dynamic well. That knowledge explains persistence. Each question invites another. Each answer opens further inquiry. Control defines outcome. Silence limits scope. Speech expands it. Choosing restraint during questioning prevents participation in building a case against yourself. 3. Invoke the Fifth Amendment. Silence alone does nothing. Many people believe staying quiet automatically activates constitutional protection. Courts have ruled otherwise. Legal precedent requires a clear verbal invocation of the Fifth Amendment before protection fully attaches. Quiet behavior without declaration leaves room for continued questioning and later interpretation by prosecutors. This distinction matters during real encounters. Officers may continue speaking, rephrasing, or waiting. Without invocation, those tactics remain lawful. Once invocation occurs, questioning must stop. That moment draws a firm boundary and shifts control back to the citizen. The correct approach depends on clarity. Speak the invocation plainly. State refusal to answer questions. After that sentence, remain silent. This sequence activates protection with full force. Hesitation weakens the position. Ambiguous conduct invites pressure. Another danger appears when a person begins talking, then falls silent. Courts have allowed partial silence to carry damaging interpretation when no invocation exists. That trap catches many. One sentence opens the door. Closing it requires spoken intent. Timing shapes outcome. Early invocation preserves consistency. Delay creates exposure. Precision removes uncertainty. Officers understand this well and may test boundaries through casual language or friendly tone. Silence remains the response. Invocation requires no explanation. It carries no burden of politeness. It demands no repetition. Once stated, it stands. Any further questioning should stop immediately. Rights exist on paper. Protection exists through execution. Clear language activates safeguards. Quiet behavior alone lacks force in courtroom analysis. Understanding this rule prevents accidental waiver and protects against pressure-driven mistakes. It transforms encounters by establishing control early, before narratives form and momentum builds against personal interests. This principle applies during roadside stops, station interviews, phone calls, and casual conversations framed as routine. Location changes nothing. Badge presence changes nothing. Legal effect depends entirely on spoken invocation. Those few words freeze the encounter and prevent further damage. Without them, conversations drift and statements accumulate. Control belongs to whoever defines the rules, and invocation defines them with precision at the earliest possible moment. If you want more lawyer-approved breakdowns like this, take a second to like the video and subscribe so you never miss the next one. 4. Never talk without a lawyer, even as a witness. Most people relax the moment an officer says one sentence. You are only a witness. That label sounds safe. It sounds temporary. It sounds like cooperation will help clear things up. In practice, that word offers zero protection. Witness status carries no legal shield, no warning, and no obligation for police to stop questioning once suspicion shifts. That shift can happen quietly, mid-conversation, without any announcement. Officers control the flow of information. They ask open questions first. They gather background. They build a timeline. As details accumulate, Inconsistencies appear, sometimes created by memory rather than deception. At that moment, the role changes. The person across the table becomes a focus rather than a helper. The questioning style adjusts. Tone remains calm, yet intent sharpens. By the time pressure becomes obvious, statements already exist in writing. Another danger lies in documentation. Interviews get summarized, not transcribed. Nuance disappears. Sarcasm reads as confidence. Uncertainty reads as evasion. Clarifications vanish. What remains becomes evidence. Once written, it travels through reports, affidavits, and charging decisions without your voice attached. A lawyer interrupts that pipeline. Representation forces communication through a controlled channel. Investigators lose direct access. Fishing stops. Strategy shifts. Either evidence already exists or momentum fades. That outcome reveals the true strength of the case. Many fear that asking for a lawyer signals guilt. Courts reject that idea. Exercising rights signals awareness, nothing more. Investigators expect it. They prepare for it. They respect it. Without counsel, every word carries exposure. With counsel, silence carries protection. The difference defines outcomes. 5. Ask this one question. Am I being detained, or am I free to go? Police encounters often feel vague by design. An officer approaches, asks questions, and keeps the interaction open-ended. Minutes pass. People assume they must remain present. That assumption hands control away. The law draws a sharp line between a voluntary encounter and detention, and that line activates with one clear question. Asking whether detention exists forces legal clarity. Officers must choose a lane. Either reasonable suspicion supports detention, or freedom applies and departure becomes lawful. There is no gray zone once the question lands. This moment matters because it transfers responsibility back to law enforcement to justify continued control. Detention carries requirements. Officers must articulate specific facts that support suspicion. Absent that foundation, continued restraint lacks legal footing. Voluntary encounters rely on consent, and consent can end at any moment through clear language and action. Courts have explained this framework repeatedly. The Supreme Court outlined the limits of brief investigative stops in Terry v. Ohio, emphasizing that police authority during encounters depends on objective justification rather than convenience. Once freedom is confirmed, the encounter should end immediately. Remaining longer invites renewed questioning. Silence becomes appropriate. Walking away preserves legality and closes the interaction cleanly. Officers may attempt friendly follow-ups. Casual tone often returns. That shift carries purpose. The safest response remains departure without explanation. Clarity dissolves pressure. Ambiguity feeds it. This question works because it reframes the interaction around rights rather than compliance. It remains calm, respectful, and effective. Used early, it prevents unnecessary exposure and restores balance during encounters that otherwise drift without boundaries. 6. Consent is the trap. Never volunteer searches, statements, or help. Consent appears harmless. It sounds cooperative. It feels polite. Legally, consent opens doors that remain closed otherwise. Searches expand. Questions deepen. Access widens. Once permission exists, control fades quickly. Law enforcement relies heavily on voluntary cooperation. Consent removes procedural barriers and accelerates discovery. Many investigations begin without evidence strong enough for a warrant. Consent bridges that gap instantly. What begins as a routine encounter can escalate within minutes. People often believe refusal signals guilt. Courts treat refusal as neutral. No penalty attaches to declining access. Evidence gathered through consent carries lasting consequences. Evidence gathered without consent faces scrutiny. That difference shapes outcomes. Another risk hides in casual help. Explaining schedules, pointing toward belongings, answering background questions, or offering context all contribute pieces. Investigators assemble those pieces into narratives. Even accurate information can support theories that grow beyond original scope. Consent also weakens future defense strategies. Courts view voluntary access as valid authorization. Challenges lose force once permission exists. Revoking consent after discovery offers limited relief. The safest approach stays consistent. Decline politely. State refusal clearly. Repeat if pressure continues. Silence follows. Firm boundaries reduce tension rather than increase it. Officers respect clarity more than hesitation. Ambiguous responses invite persuasion. Clear refusals and discussion. Rights protect through exercise. Volunteering bypasses safeguards. Declining preserves them. In encounters with authority, restraint consistently outperforms explanation. Bonus tip: control the record. One of the most overlooked advantages during police encounters is documentation. Officers record. Dash cameras run. Body cameras capture selected angles. Citizens often rely on memory alone. That imbalance matters. Creating your own record restores balance. Recording interactions where legally permitted protects accuracy. Tone, timing, and sequence stay intact. Statements remain contextual. Behavior remains visible. A clean record prevents selective summaries from becoming the only narrative. Documentation also influences conduct. Awareness of recording often improves professionalism on both sides. It discourages escalation and encourages clarity. Calm. Factual exchanges replace speculation. Another layer matters. Immediately after an encounter, write down details. Time, location, badge numbers, exact language used. Memory fades quickly. Early documentation preserves accuracy. That record supports counsel later. This strategy differs from argument. It avoids confrontation. It focuses on preservation. Recording and note-taking require no permission in many jurisdictions and carry no obligation to disclose immediately. Control of the record equals control of narrative. Voices fade. Video remains. Notes anchor timelines. These tools support defense long before courts become involved. Preparation defines outcomes. Documentation prepares quietly and effectively. Outro. Police encounters move fast. Words carry weight. Silence carries protection. Understanding these principles changes outcomes before cases ever exist. Knowledge removes panic. Clarity replaces confusion. Preparation outperforms reaction every time. These rules do not encourage conflict. They encourage awareness. Exercising rights stays lawful, calm, and effective when done correctly. Protection begins before mistakes happen. If this breakdown helped you think more clearly, support the channel by hitting like, subscribing, and sharing this with someone who needs it. Stay informed, stay prepared, and stay in control.